If you have experience in the for-profit world, you've likely heard the common advice that you should incorporate a new business in the state of Delaware. But does that advice hold true in the nonprofit world? Today, we're going to dig into this topic and find out. Hi, I'm Greg McRae, founder and CEO of Foundation Group, and welcome once again to our 501c3 University channel. The automatic advice for startups is to incorporate in Delaware, right? And there is a certain logic to it. More than 60% of the Fortune 500 is incorporated there, and most IPOs involve a Delaware corporation. There's distinct advantages for a business that incorporates in Delaware, so it's natural to ask, if it benefits a for-profit company, won't it also benefit my nonprofit to incorporate there? Definitely watch this video all the way through, but spoiler alert, we think the answer is no. Some attorneys and other groups say yes to that question, but their logic's pretty thin. Often I think some attorneys just prefer the ease of working with a single state, regardless of the consequences to the nonprofit itself. But before we get into specifics of why we think it's no, let's briefly look at why some for-profits prefer incorporating in Delaware. Delaware is known as the most business-friendly state with regard to corporate law, and the reasons many companies choose to incorporate in Delaware include flexible governance and structuring of organizations. Delaware does not require naming corporate officers, more on that in a minute. Delaware does not require fees for any state government approvals, such as amendments and dissolutions, and there is no corporate income tax from Delaware if you do business in another state. And finally, Delaware does not have taxes on stock shares for non-Delaware residents. That's a pretty compelling list, but does that really benefit your nonprofit? While those benefits have a certain appeal, you have to look at the big picture. If your plan to start a nonprofit includes filing for 501c3 status, then the flexibility of governance allowed by Delaware will not apply. For example, the IRS frowns on public charities seeking 501c3 status with only one director on board, something Delaware allows. Additionally, officers and directors must be named on IRS Form 1023, the application for 501c3 status, plus on the annual Form 990. So the privacy granted at the state level, it's not going to work at the federal level either. I recently read an article by a New York attorney who swears by Delaware incorporation. The article went on and on about all the corporate-friendly reasons why Delaware is the better choice. Now, we'll link that article below in fairness in case you want to check out an alternate opinion. The problem is, none of those reasons really make any sense if you're not basing your operations in Delaware. Yes, they may help you get incorporated faster, but honestly, is that a valid reason? Not in our opinion. It will actually cost you more time and more money in the long run. And here's why. The real headache begins when it comes to registering your new Delaware nonprofit in your actual state of operations. In order to operate in a different state than your incorporated state, most state governments require nonprofits to file a certificate of authority. And a certificate of authority can cost more than your initial incorporation filings had you just incorporated in your home state to begin with. Another touted benefit of Delaware incorporation is that Delaware does not require an annual charitable solicitations registration. That's great, but if you're not basing your operations in Delaware, what benefit does that serve? Being incorporated in Delaware will not exempt you from having to register with your home state if it's one of the 39 that require registration. And that's on top of the certificate of authority you've already had to file. One more supposed benefit that I'll debunk is that you don't have to get pre-approval from any state agencies in Delaware before you incorporate. This is often touted as a reason for New York nonprofits in particular to incorporate in Delaware, since New York often requires agency pre-approval. Well, as you've probably already guessed, it doesn't matter if you're going to operate in New York, you're still accountable to New York agencies. As many of you know, Foundation Group has helped establish over 25,000 nonprofits nationwide. And based on our experience, our general advice is to incorporate in the state in which you will primarily operate. If it's in California, incorporate in California. If it's Florida, then Florida. Even New York. Doing so will save you in the long run when it comes to maintaining compliance in your primary state of operations. There may be outlier exceptions to this, of course, but overall, there just simply is not enough benefit to incorporating in Delaware to outweigh having to comply with two states instead of one. I hope this video helped you. Would love for you to click on that like button if you enjoyed the video, subscribe to our channel if you haven't already, and click the little bell icon to be notified of new content when we post it. Thanks for watching, and we'll see you next time.